And we will go ahead and I'll get started on our intro. So welcome to Mental Health Advanced Directives. We're going to be learning about our Declaration of Mental Health Treatment form and how that can be utilized with clients. And we have Dr. Andrea Avila, and we are very happy that we could have this training and that you are joining us today. Going to go over some housekeeping, training, etiquette, CEU details. So we would like you to keep yourselves muted. We are going to utilize the chat for questions and comments, but we're going to wait to probably answer most of those until after the presentation. And we will be sending you a few follow-up emails, two mainly. So the first one is going to have all the slide presentations sent to you, a link to the recording that is posted on our YouTube channel that has probably over 40 different trainings over the last 3 years. And we also we'll be sending any sort of additional materials that Dr. Avila wants us to send out. And then we also will be asking you to respond to an email from PSU. So they are our evaluator team, and they will be able to give you a certificate of completion. And if you want CEUs, then you'll have to respond to the survey for the CEUs as well. Okay, so the next thing is we want to do an intro. I'm going to back up for the Older Adult Behavioral Health Initiative. So this is put on as part of our geriatric competency series. Even though these directives are for anyone 18 and over, but we see the benefit of teaching people about this amazing tool that we have at our hands. So the Behavioral Health Initiative was launched in 2015 to meet the needs of older adults and people with physical disabilities. And we want to improve access to care. We do collaboration and coordination, build knowledge capacity through trainings and community education, and we also provide complex care consultations. So there's 24 of us across the state of Oregon. The Oregon Health Authority funds us, and you can find out who your county's older adult specialist or specialists are by going to our website, oregonbhi.org, and you can find a Find Your Specialist tab, and it'll give you the contact information, and we are a really great resource for you all to utilize for anyone in your county who is an older adult or someone who has a physical disability 18 years and older. Okay, so this is part of a series, and we have 2 more coming up for this year. So we have in October, Dr. Maureen Nash, and she will be teaching on managing challenging behaviors in residential care settings. And then in November, we have Dr. Samantha Winemaker and Dr. Cian Xiao. They are from Canada, and they are presenting on how to navigate a life-changing diagnosis, talking about palliative care, and this wraps into advanced care planning and helping individuals and caregivers navigate serious illness and life-changing diagnoses. So please email, and we'll send out a link to register for these other classes. And we always give CEUs out, so free CEUs, 2 of them for each of the trainings. Okay, let's see. I'm gonna stop sharing and give a little bio for our presenter today, Andrea Avila. So Andrea is a licensed attorney, licensed psychologist, and a certified forensic evaluator. She works full-time at the Oregon State Hospital as an assessment psychologist. She also works in private practice, providing individual therapy, forensic evaluations, and consulting services. She is the founder of My Mental Health Advanced Directive, which is a nonprofit dedicated to the promotion of mental health advanced directive use in Oregon. Although her work primarily serves people with serious mental illness, she is very passionate about promoting the use of mental health advanced directives for anyone who would like to access them. So I'm going to hand it off to Andrea, and yeah, you're on.
Thank you so much. Hi, friends. Good morning. Thank you for being here. I'm excited to talk about these with you this morning, and I hope you're excited to hear about them. And if you're excited about the free CEUs, I understand that as well. And I'm so glad you're here, and hopefully it won't be too painful as we go through some of this information. But so today's presentation, I'm going to tell you a little bit about me first, so you know who's presenting to you, go over the learning objectives for today's presentation, talk a little bit about what DMHTs are, including how they work in Oregon. And we just had some pretty significant updates from the legislative season that just ended a couple of months ago. So we'll talk some about those updates as well. I'm going to give you some information about research on outcomes associated with DMHTs. And then once you're hopefully invested in why DMHTs are helpful and meaningful and familiar with how they work, we'll walk through the actual form together so that you can feel confident in your ability to talk about it with others. And I will also share some information about resources that might be helpful to you, and hopefully talk about ways to start this conversation with folks that you work with. We're going to cover all of that in about 2 hours. So I'm going to try to move through this information at a reasonable clip, but I invite you to put especially any clarifying questions in the chat. As you heard, someone will be helping us monitor that and hopefully letting me know, I'm sure, if there are any clarifying questions that'll be helpful for people to understand. I can't see the chat, but just let us know if you have any of those questions that impact your understanding as we go through. Also, I realize I've said DMHTs several times already. In Oregon, mental health advanced directives under the law are referred to as declarations for mental health treatment. So you'll hear me use that acronym a lot, and that's what it means. So first off, as Angela already mentioned, I'm a licensed psychologist, a licensed attorney, and a certified forensic evaluator. I work primarily at Oregon State Hospital with people with SMI. Obviously, my views are my own. I always have to say that. I'm not here representing OHA or OSH, but that does color my experience and how I approach these and why they're important to me. My personal training and background is in psychosocial rehabilitation and with a focus on recovery orientation for people with serious mental illness. And so a big part of my training was learning to look at disabilities as diversity and differences in the way that people approach their lives, and that my work is primarily, the aim of it is to help people live a life that is meaningful to them and work around any differences and abilities that they might experience to have a life that they enjoy and that's
Are we frozen? Yeah. Okay.
It was funny watching everybody's heads pop up.
forensic. Oh, hang on.
So
Someone's
Andrea,
not...
you froze for a second.
Oh no.
Yeah. And
Okay.
but I think just for the last like 10 seconds.
Okay.
Yeah.
I'll try to repeat what I was saying. I got a little pop-up that said my internet connection was unstable, so hopefully that is the only time that happens. But whenever I went to law school, I focused on learning about disability rights law. And then I also kind of transitioned into learning a bit about criminal law because, as I'm sure everyone's aware, people with serious mental illness are increasingly criminalized, especially in the United States. And so I kind of followed people with SMI into the criminal justice system, and I cross-trained into forensics, which is how I also ended up being a certified forensic evaluator. So that's a bit about my background, my training, my sort of approach to this work. I normally love to encourage discussions and debate, and it's a little bit harder to do that in this format. So I hope people are able to put any questions that they have in the chat, and hopefully we'll be able to have a little bit of a conversation at the end. It's a little bit more interactive. Okay, so here are the learning objectives. Hopefully you saw those in the email. Hopefully this is part of why you signed up. But we'll be going over the DMHT form, going over how DMHTs work in Oregon, and learning about the theory behind DMHTs and how it's consistent with the values of benefits, autonomy, and justice, and how to ensure those values are incorporated into the implementation of DMHTs. All right. So a declaration for mental health treatment, or a mental health advance directive, fundamentally at its core, it is informed consent given in advance. It is written down informed consent that allows people to document what their choices are. So if at any point during this presentation or in the future, whenever you're trying to work with these documents, you get stuck and you're not sure how it would work in a certain scenario, or what to advise someone, if you kind of back out and imagine that document as a living human being in front of you, just voicing their informed consent, saying what it is that they want, that's probably going to help you navigate whatever decision you would like. I think people get
Okay, when she comes back, I'm going to ask her probably to turn off her video, and that might help with getting stuck.
So
Andrea, I
oh,
think
no.
that if you turn off your video,
If I
it
turn off
might
my
help.
video,
Yeah,
it'll
turn
help.
off your video, and then yeah, that will probably help.
Okay. I think I turned off my video, but I can still see it.
I can still see you also.
I don't know how to turn it off. Let me try the manual switch.
That is just turning off your, yeah. If you put that one back on, and then at the bottom, if you click on video next to the audio, then that should turn off your video.
It has a cross through it. It's telling me that
Oh,
it's turned off, so I don't know why
huh.
that's happening.
Okay. Well, we'll just keep going.
I'm so sorry. This is so frustrating.
It's okay. Oh, and
Camera? Yeah.
we just lost you just for a second, so.
Okay. Well, hopefully you guys heard what I said about it's just informed consent in advance, right?
Yep.
So part of the DMHT can be about written directives, and then part of the DMHT can be about identifying a representative who's essentially just a substitute decision maker. So it's somewhat conceptually similar to guardianship, but it's a less global substitute decision making. So with guardianship, obviously the person can make decisions for the individual across a wide variety of topics. With a DMHT, they're only making decisions for that person about mental health treatment. Also, guardianship is difficult to get in place and difficult to get out of place. There have been like several high-profile cases in recent years where celebrities or other people who've drawn a lot of media attention have been under guardianships or conservatorships, and there have been like documentaries about how difficult it was for them to get out from underneath those. DMHTs are intended to be more nimble than that, a little bit more nuanced. So they're more narrow in scope in terms of that decision-making capacity. And then they're to be put into place, you need 2 licensed providers or a court to say that someone has been incapacitated. And to take it out of place, you need 2 providers or a court to say that the individual has capacity to make their own healthcare choices. And so overall, a DMHT is supposed to be kind of more flexible, and easier to put into place and take out of place, and more limited. So essentially, those come into play whenever a person's ability to receive and evaluate information effectively or communicate their decisions is impaired to the extent that they are lacking the capacity to make mental health treatment choices. And we're going to go a little bit more into that definition later. Oregon statute, one of the changes that happened this year is that, there we go. I think the video finally just turned off. So whenever it comes to some of the changes that happened in Oregon statute, those were related to defining what incapacity to make healthcare choices means a little bit better. A lot of folks, a lot of the feedback that we got from providers and from courts was that they didn't know how to implement these. They didn't know how to evaluate that. And so part of the changes that were made this year were to make that more specific and more clear so that folks were not having so much trouble even being able to approach these. I also want to emphasize that capacity to make mental health care choices is different than a civil commitment standard or any other incompetencies. So like incompetency to stand trial. It's also not synonymous with someone not giving assent in the moment. So you could have someone who is wanting access to a particular type of treatment, but for whatever reason in that moment, they don't have the capacity to give informed consent. And so I think sometimes whenever people talk about these, there's an assumption that the person who would have their DMHT activated would be either dangerous to themselves or others, or that they would be incompetent in other regards, which is definitely not an assumption that we want to make, or that the person would be resistant and not wanting to have this treatment. And that's just not something that we've seen borne out in the literature about how these usually work. Okay. There we go. So the elements of a DMHT are outlined in state statute. The exact form verbatim is in the state statute. And so whenever you see forms like the OHA form on DMHTs, they're just copying and pasting that statutory language into the form. And then they usually make it a little bit more accessible, have some formatting on it, have FAQs around it. But essentially everything that you need is outlined in Oregon state statute. If you've ever had experience with executing a will or a healthcare power of attorney, these documents are designed very much in the same way. So I know a lot of times, especially in the mental health system, since it's so connected sometimes to the criminal justice or even the civil commitment system, or at least in my world it is, we tend to think of these, evaluations as being almost like formal forensic evaluations, but this is meant to be in the same kind of category of law as wills and healthcare power of attorney. So you don't, whenever someone is executing one of these, they don't necessarily have to have a formal assessment ahead of time. Sometimes people want those, or sometimes they can be helpful, but anyone, and the quote from the statutory language is an adult of sound mind. So anyone who would be able to execute a will or a healthcare power of attorney, they can do one of these as well to outline what they would want for mental health treatment in case they couldn't speak for themselves. Some of the components of the form are pretty intuitive, like you need to have the identifying information of the person and their signature. You can have a representative or specific treatment outlined, or both, but you need to have at least one or the other, usually, otherwise it's not going to be a helpful document. There have to be two witnesses or a notary who observe the individual signing the document. And I'm going to use the word principal sometimes because that's the word that's also used in like wills and power of attorney law. The principal is the person who's executing these documents. And so they can put any information in there that's going to be helpful. Sometimes it's specific consents of like, these are the medications that I'm taking, these are the dosages that I am taking them at, or these are the facilities that I've been in before that are really helpful. I trust these providers. Or it can be other relevant information that's not specific treatment. Things like, this is the person who you want to contact to let them know that I'm here, I'm under your care, or this is where you want to get records information from, or these are allergies that I have, or these are accommodations that I need for a disability, or these are cultural considerations or religious preferences, anything like that. I recently did study with a friend of mine who works in the VA in the Southwestern United States. And one of the things that we found in DMHTs that were implemented through the VA is service animals were really common, people requesting access to their service animals. So it's important to know that these documents can contain a lot of different information. Under Oregon law, the specific treatments that can be authorized by a DMHT include medications, placement in healthcare facilities, which can include inpatient treatment or adult foster homes, residential treatment, group homes. It also can include consent to ECT, and there's no time limit given for how long someone can consent to any of those levels of care. So a person can say, I would like to take these medications and have that be a preference that stands for an indeterminate amount of time. Whenever it comes to placement in a healthcare facility, the individual can say exactly what they consent to. So they can say that they consent to a specific number of days if they would like to put a limit on that. For the witnesses who are observing the principal execute their DMHT, they have to just have the individual be known to them. In the hospital, the way that we do this is the provider, if they see the individual's patient ID, that counts as being able to know who that person is. The principal has to sign the document in their presence, and then all the witnesses are attesting to is essentially that the person appears to be of sound mind and they do not appear to be under duress, fraud, or undue influence. So similar, if you've ever witnessed someone execute a will, it's the exact same process. There are some limitations on who can be a witness. So the provider of the principal or a relative of the provider of the principal cannot be a witness. An owner operator or their relative of a healthcare facility in which the individual is a resident, they cannot be a witness. And a person who is related to the principal by blood, marriage, or adoption cannot be a witness. Once the DMHT is executed and it is delivered to the provider, it must become a part of their medical record under Oregon law. And then there's also additional federal laws and regulations that come into play here. So for example, the Joint Commission and CMS, the Center for Medicare and Medicaid Services, they say that any advance directive has to be in the medical record in a prominent place. And Oregon statute also says that it has to be in a prominent place so that other people can find it. So whenever it comes to providers, I think sometimes folks can get really nervous around these. One thing that I hear a lot from providers and their concerns are essentially that they're worried that the documents can somehow force them to override their clinical judgment, that they can be forced to do something that they wouldn't normally consent to. And so here again, I think it's really helpful to come back to that place where we imagine the DMHT as like a living, breathing person in front of us, just telling us what they want and giving us their informed consent in that moment. It's not a magic document. It is just their informed consent written down and documented in advance. Providers, if they're in a position that they don't feel comfortable with, just like with any other individual who they might serve, they can withdraw from helping that person or from providing services to that person. They need to do that in an ethical way, but that's allowed. There is protection against criminal prosecution, civil liability, and professional disciplinary action if a provider relies on a DMHT, acts in accordance with it, and then something happens after the fact and they find out, oh no, this was an invalid DMHT. There's immunity for good faith reliance on that. Under Oregon law, technically, all healthcare organizations are required to have written policies outlining how they share information about DMHTs with all adults who are in their services. Now, technically, while that's a requirement, there's no real teeth behind that legal requirement. So the Oregon law explicitly says that while it's required, an institution will not be subject to criminal prosecution or civil liability for failure to comply. But there is technically a requirement that healthcare organizations have those written policies in place and are sharing information on a regular basis with people who might want a DMHT, or to find out about DMHTs that are already in place. No one can be required to execute a DMHT for insurance purposes or as a condition of receiving mental or physical health services or as a condition of discharging from a healthcare facility. And that's what's specifically outlined under Oregon law. But whenever we go over the research in just a moment, I think that you'll see that overall, these documents and the outcomes that they're associated with, that is preconditioned on the idea that folks are able to initiate these of their own free will. Like the only reason these work, the only reason they have the good outcomes that they have is because people are being built up in their self-determination, in their empowerment, and in their autonomy and their ability to make their own choices. So I would argue Oregon law doesn't go far enough in that regard, but there is at least this explicit prohibition on insurance for receiving services and for discharge. Overall, DMHTs and information about them, how to fill one out, those should be presented with neutrality, and should never be required or prescribed in any situation. It's also important to note that in Oregon, and this varies a little bit by state, so if you find yourself in a different state, you'll want to familiarize yourself with the laws there. But the legal conditions that allow for the override of informed consent of people who are standing there, in front of you, denying informed consent for something, those legal conditions also allow to override a DMHT. So good examples of this are court orders and emergencies. If someone is being treated pursuant to a court order, like a civil commitment order, or in my setting where I work, we obviously have folks who have been committed to the hospital for competency to stand trial, restorative services, and because they've been adjudicated guilty except for insanity. So those folks are being treated pursuant to a court order, and there are already rules that are outlined in Oregon administrative rules about how their informed consent might be overridden. And so those same contingencies apply even with a DMHT. So again, I think that comparison of just imagining that it's sort of a person in front of you giving their verbal informed consent can be really helpful in trying to figure out how these things work. Okay. So the DMHT representative, this is the individual who is the substitute decision maker. They're not required, but they can be really helpful. Sometimes you'll hear them referred to as the attorney, in fact, but this person does not have to be an attorney. This can often be a barrier for people. I sometimes hear people have concerns, about, oh, I can't do a DMHT. I don't have anyone to serve as my representative. And you don't have to have one. If it's going to be a barrier for someone, then let them fill out the rest of the DMHT with their preferences. And this person does not have to be named. And you can always add someone later. The individual does have to accept the appointment in writing. So there's a place in the form for the representative to sign and say, I'm willing to serve in this role. People can name a backup representative. So if you've ever gone through the process of doing a will or a healthcare power of attorney, the attorney who probably walked you through that process asked, a million contingency questions about, what if the person who you've selected to serve as the executor of your estate, isn't available or dies before you. And so oftentimes having multiple representatives, if possible, who are available to serve in this role is helpful. The individual who serves in this role is required to act in good faith. So they need to take the written wishes and implement them as close to fidelity as they can. And they need to, if they don't know exactly what your wishes are in a particular moment, act in what they believe to be your best interest. Your representative cannot be an unrelated provider or healthcare facility owner, operator, or employee. There are other common sense provisions as well, like it can't be someone who previously had guardianship of a person and their ability to care for that person was terminated because of abuse allegations, substantiated abuse allegations, or things like that. But yeah, as long as the individual is acting in good faith, there's again that immunity from civil prosecution, civil liability, or professional disciplinary action if they are found for some reason to have not done what the individual wanted. Okay. So there were two big updates from this legislative season, and the first is related to civil commitment. The second is related to who can make the decisions that someone is capacitated or incapacitated, and how they make the decisions that someone has capacity or doesn't. But the first big change is around civil commitment. So anytime an individual is facing civil commitment, there's an obligation for the government to respect whatever the least intrusive option would be for that person, right? Like, as a general constitutional civil rights principle of our government, the least intrusive but sufficient option is what should be happening. So as you may be aware, that means that if someone is facing a civil commitment process, they can opt for voluntary treatment as long as everyone agrees that the treatment that they're voluntarily selecting is sufficient to address the concerns that initiated the civil commitment process in the first place. So then what happens if you have an individual who is facing a civil commitment procedure and they would normally select a voluntary treatment option as an off-ramp, but they don't have the capacity to consent to the treatment that they would give assent to or that they would agree to. So now in Oregon, we have an explicit process about how DMHTs and civil commitment should intersect. So, I would argue that even before we had explicitly written this into the statute, it should have applied. Like, people should have been able to use the DMHT in place of that, informed consent, and use that as an off-ramp. But again, I think having a really explicit process outlined just helps everyone feel more confident in how to navigate these. So if anyone who you are working with has had a history of being even under investigation for civil commitment in the past, this might be a way to kind of open that door and start having that conversation with anyone who you're working with about, like, if you want to try to have control over that process in the future, let's have one of these documents in place, because look at this process. But essentially, it says that once the investigator is involved, if they find any evidence of a DMHT, it's not up to the investigator to decide whether it's a valid DMHT or an appropriate DMHT or anything like that. The investigator is to notify the attorney who's representing the person who's facing civil commitment, notify the court and provide all of this information to the court that they have about the DMHT. And then if there is a representative identified, the investigator needs to notify that person as well. And so then what happens is there's this little, I don't know, like side quest during the civil commitment process where if someone has a DMHT that is discovered, then they have a hearing on the DMHT to determine, first of all, does the person have capacity to give consent to mental health care treatment? And if so, then that's it. That's the end of it. There's nothing further done. And then it's up to that person to voluntarily consent to a diversion or not. But if the person does not have capacity, then the court goes on to find whether a valid DMHT is present. So was it executed? Has it not been revoked? Were all of the elements present? And then if so, what treatment is authorized or prohibited by the DMHT? So finding these just factual observations, and there's a time limit on that. If I remember correctly, I think it's a day. So they have one judicial day and they have to make this determination. And then that information goes back to the providers. So hopefully at this point, there's a conversation happening between the providers and the individual, the principal who has the DMHT, and their representative, if there is a representative, and the attorney who's representing that person, so that they can then say, okay, is what the court found was authorized in the DMHT, is that going to be sufficient to address everyone's concerns here? And at that point, they can say, yes, it is sufficient. And then the civil commitment process ends. It's dismissed and the person is treated according to their DMHT. If it's not sufficient, then the civil commitment process continues. So it's almost like the person gave consent to a treatment that does not, meet the requirements of the voluntary diversion. So the point of this was to have equity for people who are facing a civil commitment process, whether or not they have consent to the capacity to consent to mental health care treatment. So I think part of the reason for putting this process in place is even attorneys and judges, I think, get a little nervous around these. This came up in particular because I talk about DMHTs to anyone who will listen, for better or for worse. And an attorney who I had worked with for a little while, she had heard me talk about these before. And then out of the blue, one day she calls me, and she's a public defender, and she says, I have a client who is facing civil commitment, and she has one of these DMHTs. I've never actually seen one before, but she has one. And her dad is her representative. And he's here. He's with her at the hospital. They're trying to get her treated according to the DMHT. He's her representative. He consents to the treatment. She's on board with it. But the hospital attorneys were concerned about it and were basically ignoring it. She was like, I don't know what to do. And so we were able to, I was able to give her some information about the statutes, and she took that back to the county attorney, and they were able to talk and get the providers and the hospital attorneys on board as well. And this woman was able to be diverted out of the civil commitment process, which, as I'm sure you know, has a lot of consequences if someone goes through that process. And she was able to be treated voluntarily, which I think is just an inherently better option for everyone involved. Okay, so the other big update that happened was around the determination of incapacity. So in the process of building that explicit court process for civil commitment, we made it basically the same process for if someone wants to use that court proceeding, but outside of the context of a civil commitment. So essentially, you can go through that proceeding that I just described, whether or not the person is facing civil commitment. So it has to happen if the person is facing civil commitment and has a DMHT, but it's optional at any point in time if someone has a DMHT. So prior to the updates from this year, you could only have a court process through a guardianship proceeding. So at that time, the way that the statute was written was that any person interested in the affairs or welfare of a person who might be placed under a guardianship could initiate those guardianship proceedings. And then as part of that, the validity of a DMHT could be determined by the court. But now this is a freestanding court process. And we kept the same language partly to keep it continuous, but also because we really wanted for anyone who was under one of these DMHTs to be able to challenge it if they needed to. Giving people access, immediate access to being able to file a petition and go to court, it reduced our concerns around potential abuse of these, especially whenever we took off, because originally there was a limitation previously where people could be placed in a healthcare facility. They could only consent for up to 17 days. But we thought that wasn't really fair, that people should have the ability to choose whatever they wanted for themselves. And so we expanded that so that people could name however long they wanted to be placed in a healthcare facility, especially because a healthcare facility can include long-term facilities, not just acute short-term inpatient care. So especially removing that time limitation on it, it felt really important to make sure that people had access to a court process to make sure that they were being treated fairly. So anyone who is interested in the affairs or the welfare of the person who has a potentially valid DMHT, including that person, can either ask for their DMHT to be honored or ask for a court determination that they have the capacity that their DMHT should no longer be in place and they should be able to make their own healthcare choices. So the two physicians, it used to be only two physicians or the court could make a determination of incapacity. One of the changes that happened is we broadened this to two licensed independent practitioners, which includes physicians, nurse practitioners, and naturopathic physicians. And then we also included licensed psychologists. So you don't have to have two of the same license type. You just have to have two of one of those four licenses, if that makes sense. So it can be a licensed psychologist and a nurse practitioner, or any combo thereof. And once they are making that determination, it should either sort of turn on or turn off the DMHT. Okay. So this is the part that I referred to a little bit earlier, where I talked about how we tried to make it more explicit in the statute about how these determinations could be made. So one thing that we had heard from a lot of people is that they just don't know how to make these decisions. And there are actually, as it happens, like several tools out available to help providers walk through the process of evaluating if someone has capacity to make healthcare choices or not. Some of these tools are for mental health care only. Some of these tools are for any kind of treatment or care. And so what we did is we looked through those tools, we pulled out some of the factors that were common and that seemed applicable to this situation, and we listed them in the statute. So these are things that are statutorily, whether it's a court or a provider, people are encouraged to consider these factors. They don't have to consider each individual factor, but it may include these factors that are listed here. And as you read through these, I'm not gonna read the slide to you, but as you read through these, I think you can see kind of intuitively why these factors would be important in determining whether or not someone has the ability to make informed consent choices around their mental health care and to communicate those choices to providers effectively. The hope was that this would just make it continue to reduce those barriers to implementation. Okay. Oops, there we go. So this is the second set. I think there's 9 total. So just again, and I don't think that this is available even on the Oregon legislative website yet. I think they're still working on the 2025 updates. If you go to that website, you'll see the 2023 version. But the bill that passed that has this language in it is available on the Oregon legislative website. Okay. So with all that information about how DMHTs work under Oregon law, these are the things that DMHTs are not going to impact, right? So if the principal has capacity to make their own healthcare choices, DMHTs are not going to touch decisions that the individual makes whenever they have capacity. Those are their choices and their choices alone. It's not going to impact what level of care the provider has assessed the person as needing. It's also not going to impact whether the medications or other treatments that are authorized by the DMHT are medically necessary or appropriate for that person. So like one example that I've seen before is an individual who at the time that they executed their DMHT, they were taking a particular medication, but then later on, whenever the DMHT went to be implemented, at that point in time, they had developed a heart condition. And so the medication was now, their medication had been changed, but the DMHT hadn't been updated. And so at that point, it was contraindicated to give them that medication. So it won't change things like that. Payment or insurance coverage for services provided by the DMHT, those are not impacted by the presence of a DMHT. I also don't know if I said this explicitly earlier. I think it might have been on the slide, but just because someone serves as a representative does not make them financially liable for the treatment of the individual. So that's an important distinction as well. Obviously, sometimes the services that are requested in a DMHT may not be available. And then the other thing that comes up a lot is whether the person is able to have transportation to wherever they need to go whenever their DMHT should be activated. So those are, I think, 2 of the biggest barriers outside of like provider concern around these or attorney and judge concern around these. The biggest issues that we see are dissemination. How does the DMHT get to where it needs to be so that the people who need to know about it? And then transportation. How does the person, the person may have consented to treatment, but they haven't consented to transportation to get them there. And if they are someone who is not, giving agreement or assent in the moment to things that they've consented to through their DMHT, how do they get transported to the location that they need to be? So those are, some of the trickiest implementation factors, I think. Okay. This is a natural breaking point. If there are any questions that have come up, we're kind of transitioning from the first part of the presentation to the next. So I just want to offer an opening, and if not, I'll keep trucking right along.
We did have one question about, can the representative be a provider as long as they're not your provider?
So that's a great question. I'm going to pop back to that slide. So I think the limitations are here that it cannot be an unrelated provider. So I think this is an acknowledgement that sometimes people work in this field and also have personal connections, and may have people in their lives who they care about and would like to support. So if it's an unrelated provider, can't be a representative. And then also if it's a related provider, they probably shouldn't have been your provider in the first place. So hopefully that wouldn't be a conflict. But does that answer the question?
I think so. I did have one question that has come up before. Are there any can't think of what the word is, but so if you are in a residential setting for like adult foster home or maybe a inpatient residential treatment for mental health, is there any reason why an employee of that facility wouldn't be able to help you like fill out a DMHT or advanced directive? Not witness, not do any of that, but just like filling out the paperwork with someone.
I think that's a great question, and there's no barrier that I know of to that.
Okay.
Some of the research that I'm going to touch on in just a second talks about how people are more successful typically whenever they have a provider who helps them fill it out, or a peer. There's also this great research that I'm going to talk about in a second, internationally from France, where they had this randomized controlled trial where folks had peer support specialists help individuals fill out a DMHT, and they had great outcomes. So there's no hesitation around having people help with filling out the documents. I think the hold on people being able to witness it is, it's almost like a separation of powers kind of thing, right? Like we don't want for one person to help them fill it out and then witness it and then also be their representative. Like that immediately starts to feel like a little suspect. But hopefully people are having conversations with their providers before they fill these out. In my world, and I would love to hear from the folks who are attending about how this has different applications, because we work in slightly different worlds. But in my world, a lot of times this conversation happens during conversations about treatment planning, or about discharge or relapse prevention planning. And so that's normally where we build these things in. And so hopefully folks are taking those conversations with their providers about relapse prevention planning and implementing some of those things into these. And then one other thing that we'll do at the hospital too, because we don't always have a ton of folks who are available to witness, is we'll swap providers. So we have two campuses, right? We have Salem and Junction City, and those providers are pretty separate, although it's not like a 100% distinction. Most of our folks who are there for competency restoration services are in Salem, and a lot of our GEI folks are in Junction City. And so we will swap providers and have providers from one unit witness documents from a different provider's units, and vice versa. And then I'm also an assessment specialist, so I don't do treatment with anyone in the hospital, and I only do assessments. And so my list of folks who I've interacted with, who I've provided services to, is much shorter than a lot of our other providers who are running groups and having all of these interactions with a lot of different people. So I've served as a witness in a couple of these as well. So hopefully that helps get some problem solving and creative juices flowing.
We do have another question that kind of
Okay.
relates to this. It says, what about notarizing? So We have a few notaries at our organization that may be willing to volunteer time to notarize these for coworkers.
Yeah, I mean, that's great. You can have a notary do them. That was an update, I think in 2023 that they changed, which really makes it, easier. And so, yeah, I mean, if you have a notary process, whatever that process is, to have someone just sign it in front of them. And just like a will, you don't have to tell the people who are observing, whether it's a notary or two witnesses, they don't have any right to know what's in the document. Like, it's still your private healthcare information. But they just have to know that it's you, see that you're signing it, and no one's forcing you to do it, and you're not like crying while you're doing it, or anything like that. That it's something you're doing of your own free will, and you appear to understand what you're doing. You're signing a DMHT. But yeah, I think that's a great process. At the hospital, we have a notary available to folks. It's a little bit more complicated. They want a built-in assessment. But that's the particular setting that I work in, and I don't think that's necessary in our setting even necessarily, but in other settings for sure.
Okay, so Meredith, does that answer your question? If not, add something in the chat. But Andrea, you can keep going if you like.
Perfect. I will start talking then about the research on DMHTs. So I know I touched on this earlier, but I simply cannot emphasize enough that this tool was developed to empower people with SMI and other people who might be at risk of experiencing involuntary treatment, or not being able to provide consent to treatment. And the outcomes that I'm about to talk about do not generalize to a system that coerces or requires DMHT compliance. So sometimes I hear exceptionally well-intentioned people say things like, oh, we're going to make everyone who goes through our program do one of these. Or, in the hospital, we're going to make everyone do one of these before they're discharged. And that is like 100% not the point, although I love the enthusiasm. So I want to touch a bit about on the principles of like recovery orientation, self-determination, and psychiatric rehabilitation. So those ideas are the active ingredients in this intervention. And I know people probably have a lot of familiarity with those phrases, and I know there's overlap. Again, we work in like slightly different fields, but there's a lot of similarities. But self-determination, whenever I use that phrase, what I'm using it to mean is the fundamental idea that the essence of being human is the right of all people to choose the meaningful expressions of their values, including how they engage in treatment. So I think that's a sort of a non-negotiable premise of this type of intervention. Psychiatric rehabilitation, I touched on this a bit earlier, but it's an approach, a treatment approach that conceptualizes all disabilities as individual differences and diversities that are to be incorporated into the development of functional capacities in multiple life domains to drive a meaningful, values-driven life. And recovery orientation, I know this phrase gets used all the time. It's a bit of a buzzword. Honestly, at this point, it's such a complex, nuanced idea that there are probably as many definitions as there are people who use the phrase. But generally speaking, whenever I use it, I'm talking about it being a hope for a self-defined future that includes a fulfilling and productive and meaningful life while adjusting to the presence of a disability. So yeah, I think one thing that's kind of cool to know is that all of the research that we're going to talk about is going to show how these interventions are consistent with those ideals. And it's also going to show, one of the things that I don't have on this slide is that people just being able to understand DMHTs and understand that this is an option that is available to them was associated with higher perceptions of autonomy later on. And I think the follow-up period was a year. So even just having an understanding that this is a treatment option that was available to you helps increase people's perceptions of their own control over their treatment, especially the group of folks who I've worked with. And I would love to hear to what extent this is true of the people that y'all work with. But a lot of times these folks have very valid reasons for not trusting the system and not being certain that their wishes are going to be respected, especially for people who've experienced involuntary treatment before. So folks with SMI, whenever they are told about DMHT type documents, they have an overwhelming preference to have them in place. In this study that I cite here, I want to say the rates were in the 70s, but few reported having this document, a document like this in place. So I'm going to point out that the citation on that last part about a few having this document in place is from 2006. 20 years later, we have not meaningfully changed these numbers. So the percentages that were cited in that study were 4 to 13% of the populations that they looked at had one of these DMHT type documents in place. Whenever I did this research with my friend in the Southwestern VA system, the prevalence rate was less than 5%. And I pulled cross-sectional data from OSH from the hospital about a year ago, and we have over 700 beds between our two campuses, and we had like 6 people who reportedly had a DMHT in place. Because here's the other thing that you'll find sometimes is someone will say something like, oh yeah, I have a DMHT, or oh yeah, I have a psychiatric advance directive, and they'll pull out a relapse prevention plan, or they'll pull out a RAP plan, a wellness recovery action plan. And those are wonderful things. Those are absolutely wonderful. They're great starting places, and they're not a legally binding DMHT. So sometimes you have to provide education to folks around whether or not their document meets those legal standards. Okay, so this last like big bullet point with these 5 sub bullet points here, I thought this study was very cool whenever I first came across it. It spoke to the fact that people with DMHTs, they find it meaningful to have these documents, not only in the event of a crisis where they don't have capacity to give consent to mental health treatment, but even just to have conversations with their providers. And some of the things that really just stuck out to me from the study are they felt that it changed how providers interacted with them, even whenever they had capacity. So they were viewed as a more responsible agent. They were viewed as someone who is, proactive and thoughtful about what they wanted for themselves. And this last bullet point, like it never fails to floor me, but to be believed by providers. And whenever I first started doing this work, I hadn't thought about that possibility, that there would be people who would walk in, and that the DMHT, even whenever they had capacity, would encourage their provider to believe them whenever they said, this is the medication that works for me, or this medication doesn't work for me, or these are the things that I need to do well in this environment, in this setting.
Dr. Avila, can you repeat the sentence that you said a moment or two ago that started with hope for a self-defined future?
Oh, yeah, let me,
Stephanie's wondering about that.
yeah, hold on, that's in my notes here, so I can maybe hopefully repeat it verbatim. Oh, I was talking about a recovery orientation. And I was saying that whenever I use the phrase, part of what I mean, like a central feature of it, is the hope for a self-defined future that includes a fulfilling and productive life, a meaningful life, while adjusting to a disability. So to me, that's what a recovery orientation means. It's that approaching treatment with that perspective in mind. Did that help?
Did that answer your question, Stephanie? Thank you.
This is great. This gives me a chance to sip my coffee really quick. Okay. Oops. Let's go here.
Another question, I don't know if this is a quick question or not, but does PTSD fall under SMI?
Does PTSD fall under SMI?
Yeah.
I think that that's a great question, and it kind of depends. So sometimes, oh gosh, there's so many different definitions of SMI. Some people will focus it in on like psychotic spectrum disorders, so schizophrenia, schizoaffective. I went to grad school in Nebraska, and weirdly enough, SMI is statutorily defined in Nebraska, and it includes things like schizophrenia and schizoaffective disorder, and then it also includes OCD, which felt like a kind of thing out of left field for me. Like those aren't normally classified together. In research, a lot of times you see SMI defined as people who are experiencing a certain level of like healthcare service utilization, or a certain level of challenges in their ability to carry out their activities of daily living. So sometimes serious mental illness is defined by that level of impairment. And I know that there are exceedingly valid criticisms of focusing on like the disability aspect or the impairment aspect, or focusing on what someone can't do. And I know even the word disability is there, very valid criticisms of it. And I find that sometimes in doing this work, it's important to carefully define the group of people who you're trying to design an intervention for, because what can happen sometimes is if there's not a focus on who is at the most need for intervention and support and services, the pool can kind of get widened, and the intervention can accidentally go sort of towards people who are not at that same level of need, and it ends up leaving behind the people who have the most profound need. So that was a very long, convoluted answer, and I don't know if I actually answered your question, but it's going to depend, I think, on what framework you're operating in and who is defining SMI in that moment. So we definitely have people in the hospital who are experiencing PTSD, and that's part of why they're there. So yeah, I don't know if that rambling answer gave you nothing but just additional thoughts.
It looks like we're good.
Okay, cool. I'll keep talking about the research on these. So a moment ago, Angela, whenever you asked your question about providers being able to help people fill these out, this is the study that I kind of foreshadowed a bit. Completion rates and just interest in these forms overall are higher when clinicians express support and they assist with them. I'll get to the peer one just in a moment. It's at the bottom of the slide. Providers often voice general support for these types of interventions, but also describe unfamiliarity, discomfort, and concerns, primarily about the legal and ethical implications. So another thing that we have seen in the research from providers is that there are some of these like pragmatic concerns. They don't know where to find the document in the electronic medical record. And you'll notice a lot of this research is from like the mid 2000s. So kind of a brief history of DMHTs. They became very popular in the United States in the 1990s, around the same time as the Americans with Disabilities Act, and as people, as a country, as we were starting to think more about what it meant to meaningfully include people with a variety of different experiences, right? And shortly after that, there was this kind of like wave of onset of these statutes in many states, not a majority of states, but many states, including in Oregon. Our law was passed, I want to say in like 1993. And then in like the mid 2000s, there was a lot of grant funding around these. There was a lot of research that was coming out at that time. And then you just see it completely kind of die off. These didn't get a ton of traction, and they were kind of abandoned. And so then you see another like pop in like the mid 2010s, but it's even smaller than the mid 2000s. And then just recently, like in the 2020s, these have started to come back again as people have grown more interested in the feasibility of implementing these and trying to address all of these crises that we've seen pop up essentially since the 1980s, with increasing, folks in criminal justice settings, an increase in incarceration and increase in our folks with disabilities being run through the criminal justice system. So, and now in, the last 10, 15 years, the competency crisis throughout the country. So there's a resurgent interest in these as potentially a tool to help dismantle these problems that we've seen really pop up over the last couple of decades. Oh, and one cool thing about that is you see an increase in, so, providers don't know where the document is available. Okay, well, now JCO and CMS regulations are that it has to be in a prominent place somewhere in the individual's file, somewhere easier to find. So even though there's some of these concerns about how to implement these, one of the other big concerns that comes up is enforceability. Will, if someone puts something in their DMHT that a provider doesn't agree with, what is that enforcement going to look like? And so I think there's a couple of things to consider around that concern. The first is just that enforceability is unlikely to be an issue. Content analyses done on DMHTs in the past indicated that like 91 to 95% were feasible overall, and 94% contained clinically useful information. So especially in Oregon, it's also important to remember that any override that would apply to a person standing in front of you giving informed consent, that override also applies to a DMHT. So that issue around enforceability, it's just less likely to be an issue. And providers can still withdraw. You remember that from an earlier slide. They need to have good faith implementation, but just like regular consent, they can withdraw if they need to. They can document why they didn't, in the case of the individual who had a medication in his DMHT that ended up being contraindicated because of a subsequent heart issue, right? Like you just document that in the file of like, this is why we didn't follow this, but we did this, instead, which was as close as we can find, or what their representative agreed to. This 1996 study is kind of cool. This is straight from Oregon. These authors of this study are the people who created the original OHA form and who were involved in the original passing of the statute. And in a minute, whenever we look at the OHA form, you'll see these names on there as authors of that form, and it's original version from back in the 1990s. But they sent out a mail survey of folks who had received information about DMHTs and asked if they had been using them and if their conditions were respected in a crisis. And the results that they got back were that people who had to use them, there was a minority of folks who had used their DMHTs, but amongst the folks who had used them, their conditions were implemented. All right, so these last two studies on this slide are both from Europe. The first one showed that there were reduced compulsory hospital admissions. And then the second one, which is out of the same research group, they had a randomized controlled trial of this large group of people who had been discharged from inpatient care, who the group that was assigned to the intervention sat down with a peer and filled out their DMHTs. And over the course of the next year, they had reduced healthcare costs and reduced utilization of services, especially higher levels of care. And a year later, they were still reporting an increased quality of life as part of having that DMHT to help manage their care in moments when they weren't able to provide consent. I also just want to kind of make a point here that if people are less likely to experience coercive interventions with these documents in place, I think not only does that help the individual who has these documents in place and the people who care about them, this also has implications for providers and staff who are caring for folks. Because, one of the conversations that we have a lot in the mental health field is about burnout. And in recent years, we've started talking more as well about the concept of moral injury. And if you're not familiar with it, burnout is obviously, sort of being stretched too thin for a very extended period of time to the point where kind of experiencing like compassion fatigue and some of these other symptoms that can really interfere with your work and how you feel about your work. But moral injury is also the idea that sometimes you're placed in a position by your job to do things that you don't really agree with. And the idea, I think for most of us, we got into this line of work to help people and to empower them and to improve the quality of their lives. And so having access to an intervention like this, where we can help folks have more autonomy and control over their own treatment choices, I think that's just incredibly powerful for us as providers as well. A lot of this research focuses on the individuals who execute them, but I think it makes a difference for us too. So this is research that I did a couple of years ago with a colleague here in Oregon. So we sent out an online survey. We got back, in terms of responses that we were able to use, we got back 225 responses, people who had completed the survey. If you happen to be one of those people from a few years ago, thank you very much. But we were looking at barriers to implementation. So we had reviewed this literature that I've already discussed with you from the past few slides about how providers are often, theoretically or conceptually excited about these, but they have all of this discomfort around implementing these. So in this survey, it was pretty brief. We started out with a vignette, and in this vignette, it was an individual who was a young man who had just had a first episode of psychosis, and he had been arrested during that first episode of psychosis, and he had gone through the competency restoration system. And obviously this was, a vignette that was kind of created from my perspective as a state hospital employee, but he'd gone through the competency restoration system, had been stabilized in community restoration services. And then he and his mother in the vignette were reaching out to the provider who's filling out the survey to ask for help for planning for a future crisis. What could they do now that he's stabilized, now that he's in a good place? What could they do to plan for future concerns and issues? And initially, we just had like open-ended responses, right? We don't want to prime anyone with anything. We just let people kind of tell us what they thought that they would do. And these open-ended questions the responses were absolutely heartbreaking. They were characterized by hopelessness, helplessness, and frustration. We got responses like, they should just move to a different state because there's not services in Oregon. No one can do anything until he hurts someone. It was just this like very, you could just feel the amount of frustration that was coming from the providers. And we opened this up to providers throughout the state. We obviously emailed it out at the hospital, but only about half of our responses were from providers at the hospital. We emailed it out, I think, via like Oregon Psychological Association. I think we were also able to coordinate with the state social work, marriage and family therapy, nurse practitioners, I think. And so we had a variety of folks from different settings who responded to this. And across the board, no one was like, yes, I feel super confident in my ability to handle this situation. And then we asked them some questions about, how confident were they in their ability to help this family? How, did they feel like they would be able to be effective in helping them? And overall, their confidence and comfort in helping the family was very low. And then we asked questions about DMHTs. We gave some like multiple choice, like, would you recommend guardianship? Would you recommend a DMHT? Would you recommend, these different options, treatment through the criminal justice system? And almost no one, a very low percentage in that initial ask about what they would recommended a DMHT. And then we asked questions about just the facts of DMHTs. So we had like 15 true false questions about how DMHTs work in Oregon. The overall correct information rate was like pretty low. I think on average, everyone failed the exam at the beginning. If you were to think of it that way, a lot of people had misinformation about the basic facts of DMHT, and they had little confidence in their ability to use a DMHT and little perceived usefulness of a DMHT. And so then we just did this like super brief intervention where we literally just had 15 bullet points that gave information about how DMHTs work in Oregon. Not even all of the outcome research that I've talked to you about. all of that, just how they work. And with that brief educational intervention, we then put them back into the 15-question true-false question quiz. And people did significantly better. Their information and understanding of how DMHTs work had improved. And then we asked them again about how they felt about being able to help the Vignette family and how they felt about being able to use a DMHT and their perceived usefulness and ease of using a DMHT. And they essentially went from low to moderate, which is a significant jump for such a brief intervention. I wasn't sure if we would get anything off of just like an emailed survey with this, probably 60-second intervention. And the increase in their confidence to use a DMHT and help the family was predicted by their knowledge after the intervention. So if they were more knowledgeable after we gave them some facts, then they were more confident. And that was very encouraging to see such a big jump off of such a small intervention, but it was also noteworthy that at the end, their confidence in their perceived usefulness of DMHTs were only in like the moderate range, like 50 to 60%, implying, obviously knowledge is part of the barrier to implementation, but as we all know, you need more than just information to be able to effectively implement some interventions like this. And so that really spoke to us that we need to provide even more pragmatic support and help people really understand how to implement these. So I've been doing trainings to anyone who will let me talk. So thanks again for being here. I'm going to talk a little bit about my MHAD, which is something that I'm trying to get started here in Oregon, that is going to be a nonprofit that is just specifically for the purposes of promoting the use of DMHTs, and it's intended to be like a very pragmatic place where people can come to find the resources that they need to use these. So one other interesting finding from this study was that even among those who said at the beginning that they were familiar with the DMHT, only 8% of the total sample had ever used one. And so it's just a very low percentage of use that kind of replicates what we saw earlier among, folks who wanted a DMHT, that there was a very low percentage of people who had one, and then there's a very low percentage of providers who have used one. So I think hopefully one of the overall takeaways from this presentation is that DMHTs have this potential to be hugely impactful. I think for the people we serve, for us as providers, for all of our loved ones, and for the general public. But we definitely need more education. We need ongoing research. We need increased pragmatic support. In my world, I think these interventions have the most potential as a pre-arrest diversionary point to hopefully give law enforcement a way to have people with SMI not even involved in the criminal justice system from the beginning. So I don't know enough about the older adult system to analogize this to the services that y'all provide, but I'll show you the math that I did, and you can hopefully find something similar in your own system. But I know that these are not going to be like an intervention that works on the level of diverting like hundreds or thousands of people out of the criminal justice system, right? But even if a DMHT were to keep 10 people a year out of where I work, the state hospital, it could make a huge difference. So this number, the 1630, is the most recent estimate that I have about how much it costs per person per day to be in the state hospital for competency restoration services. And this estimate is taken from national research about the average length of time for competency restoration. So if we were able to divert 10 people from competency restoration at the state hospital, it would save over $2 million. Just that small change could have a large fiscal impact. And so whatever the equivalent of this math formula is for wherever you are working, your agency, sometimes if you can't get people on board because it's the right thing to do, or because the research supports it, or because Oregon state statute has this, toothless requirement to have policies written about how to share this information with the people you serve. Sometimes the fiscal analysis can also help. So just to put that out there. Let's see. So with that kind of background and understanding, I want to go through the actual parts of the form with y'all now. So unfortunately, OHA has this like PDF that they put out that includes verbatim the statute language, the statutory language. Right now, that form is being updated. I don't know, we're supposed to have an updated form, I think by the end of the year, but we don't have it just yet. So the one that's available right now on OHA's website is technically outdated and it doesn't have the updates from this year yet. But the contents of the form are in ORS 127-736, which you can find that very, very easily. I have a link to it later in the slides. But this is the form at the top. The heading of each slide includes which section of the form that we're in. So this is the very top of the form, the very first thing that's there. And it says, you know, I, the principal, the person who's executing this, being an adult of sound mind, and making these choices. So I want to just point out a couple of the definitions that are here. So mental health treatment. Earlier, you may have recalled me saying that under Oregon law, mental health treatment means the treatment of mental illness with medication, admission to a healthcare facility, electroconvulsive treatment, or outpatient services that are specified in the declaration. A healthcare facility, again, could include a variety of different settings. I catch myself still doing this sometimes, and people often do this to think that a healthcare facility or what someone is giving consent to for that unspecified or whatever period of time they specify is always an inpatient setting. So I have to constantly remind myself that healthcare facility could be any of these levels of care. Capacity evaluator is just the simplest term that we could come up with instead of always saying 2 licensed psychologists or 2 independent practitioners. So that is what that means. This, I think, is probably the most confusing part of the form. The most questions that I get asked are related to this part of the form. So this is the second section. So you just have that top part where you're basically signing your, or just writing your name. It's not your signature yet. But here it says choice of decision maker, and it appears that you're choosing between a representative and a mental health treatment provider, which if you recall from earlier, your mental health treatment provider cannot be your representative, right? But the way that this is phrased is a little confusing, but it basically means, do you have a representative or not? And if not, that's the second option there. And that just means your mental health treatment provider is just going to use the instructions in your declaration because you do not have a representative. So I hope that makes sense. I often get questions about this part, and it is confusingly phrased. Let's see. So this is the part about the appointed representative. And it says, essentially, if you are going to appoint a representative, you name them here. And you can name a backup. You need to have their name, their address, and their telephone number. I think having a backup is a great idea. I think having a representative in the first place is a great idea. And lots of people may not have a representative, much less a backup. And then that's totally okay. If that's the situation, you just skip this section. You don't have to fill it out. It's just not part of the DMHT that person is doing. It's noteworthy that if the person doesn't know, the representative doesn't know what the principal wants, then they have to act in what they believe to be their best interests. Let's see, that. And then the next part of the form is where you get to actually give the substantive directions. So again, you don't have to fill this part out. You can just name a representative and be done. But if you would like to, even if your representative is someone who you trust very much, who you think knows you through and through, heart and soul, it's not a bad idea to write down some instructions. If someone's trying to make these decisions, chances are they're under a little bit of stress. And so it's not a bad idea to have them written down for people to know. But you can identify specific medications, specific facilities, if there's places where you feel more comfortable. You can specify, you can either initial for 14 days, 30 days, 60 days, or you can specify a length of days. You can also just give any general information that might be helpful in consideration for your mental health treatment. A big thing here too is also you can give consent to transportation, which I mentioned earlier is often a barrier for folks whenever they try to implement these. Let's see. There's also a section to explicitly say what you do not consent to. And so there's a prompt there to also consider including like why you're not consenting to that. So for example, if there's a medication that you have an allergic reaction to maybe include that information. I think it's, kind of a bummer. But the reality is that including a reason like that might make it easier for providers to interpret and implement that information. They should just use it because it's there, but providing a reason might help people understand why that is something that you're not consenting to. Let's see. There are also at the end of the form, right after this section, there's notices to the principal, the person who's signing the DMHT, and to the providers of basically everything that we've already talked about. So things like letting the principal know that if they are being treated subject to a court order, then their wishes can be overridden. So that's something to notice that there's that information also included at the end of the form. And then everybody has to sign it. The witnesses or notary has to sign it. The principal has to sign it. And the representative, if they are being named, have to also sign it. Okay. So I'm going to talk a little bit about, hopefully, now that you know how these work, the outcomes that are associated with them, the barriers that have been identified to implementing them. Here's how we can maximize, hopefully, the impact of these documents. So familiarizing yourself with the research, the law, and available resources. If your organization does not have written policies for how and when information about DMHTs are shared with clients, create them and build it into conversations that are already regularly scheduled and that are taking place. And then follow those policies. Help people in your organization follow those policies. Look for openings for additional discussion. So if someone expresses an interest in an outcome associated with DMHTs, capitalize on that. Talk with them about how DMHTs work. If you ever have the opportunity to make recommendations, or if you're putting together treatment plans, build in DMHT information whenever that might be appropriate. Now that list of factors that are to be considered when determining whether or not someone has capacity is like outlined clearly in the statute, you can check that at any point in time. And if there's information that you are coming across in whatever your regular documentation practices are, if there's information that you can document that might be crucial to those determinations, document it. And then it can help later on if there's a consideration of whether or not someone has capacity to make healthcare choices. Offer support for people who might be attempting to complete one, both like pragmatic support, like identifying witnesses, and substantive support, like encouraging them to include their providers or their loved ones in that conversation. And then to the extent that you can, help people problem solve in advance. So, who are they going to disseminate the document to? When are they going to update it? Also, I think this was on one of the slides, but I may not have explicitly said it. DMHTs expire after 3 years unless they're in use. So every 3 years, the document needs to be updated unless the person is at that 3-year mark, incapacitated, and being treated under their DMHT. So the good news is you can check off number one from attending this webinar today. You've learned about the research, you've learned about the law, and I'm about to tell you about some available resources. Let's see. There's also, just so people are aware, there's also a LEDS voluntary database. So that's the law enforcement data. I can't remember what the S stands for, but it's essentially whenever officers interact with someone, they can search for someone in that database and notifications will come up. So I know from my work at the hospital, if we have folks who have been adjudicated GEI, who are under PSRB supervision, but who are in a community placement, and they are there's an interaction with police. Whenever police search that LEDS database, they see a notification that they're a PSRB client and to notify the PSRB. And so there's an optional way for people to voluntarily enter their DMHT information into the LEDS database. That's obviously a complicated and nuanced decision to make that people should make carefully. And also as far as I can tell, we've been trying to track this down for a bit, but as far as we can tell, the way to get that information into the database, there's not a good mechanism right now. It's theoretically something that can happen, but it's not something that can happen easily. But just across the board, as you're looking to implement these, always, focusing on centering the patient's wishes, advise them about the risks or benefits, but we want to let people make their own choices around this. And you want to be sensitive to potential sources of external pressure and to do your best to make sure that the individual is acting on their own behalf, right? So we know that even well-intentioned family members can sometimes become maybe a bit strong of a presence in the room or have a lot of sway over someone, especially if that person's dependent on them in some way for care. And so, making sure that the person's really able to kind of define what they want for themselves. And so while we want to include loved ones and providers in those discussions, maybe meet with them, once on their own to make sure that what they're saying they want is really actually what they want. If you find yourself, I don't think this happens very often, but as these are becoming more popular, there's some very valid concern that DMHTs might be ordered as part of involvement in the criminal justice system. So as a condition of probation, or something like that. And especially because Oregon law only has that explicit prohibition against requiring DMHTs for the purposes of insurance, access to treatment, or discharge from a healthcare facility. That requiring people to do it in that situation technically isn't barred by Oregon law, even if it's a terrible idea. So you may want to consider noting that the DMHT is being executed under those conditions. If there's anything about it that feels coercive, if you can't stop the whole process, you can at least document how it happened. Let's see. Right. So this is our resources page. And I think actually what I'm going to do is I'm going to come back to this in just a moment so that I can stop sharing my slide and maybe show some of these things so people understand how they work. But the last thing that I want to do is just sort of pull up before I go into those resources, is just pull up the learning objectives again. So I hope at this point you feel familiar with the DMHT form created by Oregon law and feel confident in your ability to answer common client questions. I hope you feel familiar with the legislative changes and how DMHTs work under Oregon law, including how to prevent a civil commitment when applicable, and that you feel like you have an understanding of how these documents are theoretically and empirically consistent with these values and how to implement those things in your practice. My last slide is just a thank you and my email address in case people have any questions, but I'm gonna stop sharing so I can click on some of these resources to show people. But this might also be an okay time for questions if anyone
Okay.
has them.
Dr. Avila, I have been keeping an eye on the chat. I just wanted to touch base on a couple of questions we may not have caught.
Okay.
One was from Sue. Her question is, who typically would initiate the freestanding court process, and would that be through family court?
That's a great question. So right now, I don't know yet who would typically initiate those proceedings because this is a brand new law. So we don't really have any like data yet on frequency of how that'll be used. I honestly imagine that for the first bit of time, probably no one's going to use it, mostly because not a lot of people know about these. So there's not going to be a lot of DMHTs to adjudicate, but I'm hoping that over time it'll become used more often. And the way that the law is set up now, it allows people to go through circuit court, is where the petition is supposed to be filed. So they not through family court, but it used to be situated through the probate court as part of the guardianship proceedings. Yeah, I hope that answered your question.
That's it. I thought we had another question from Dawn, but I'm not seeing it now. So maybe she logged out. Dawn, if you're still there, please put your question back in the chat.
So Dawn asked, if someone writes mental health treatment preferences in a advanced directive, so would that be considered a DMHT, or do those mental health treatments need to be done in a DMHT?
That's a great question, and I'm not certain of the answer to that. I have cautiously and optimistically turned my camera back on, so if it starts glitching again, just let me know. But I don't know. I don't know of any case where that's been litigated. I could see someone arguing, we have a DMHT form, so they didn't use the DMHT form and they should have used the DMHT form if that's what they wanted to do. And I could see someone else arguing like, the whole point of these is for people to be able to communicate what they want, and that has been done effectively. We understand what they want. So I'm really not sure. That would be a very interesting question to have a court actually make a decision on. But I don't know of any cases like that in Oregon or anywhere else in the country where they've had to decide something like that.
Because I would imagine in your advanced directive, you are giving your decision maker, your surrogate decision maker, the ability to make healthcare decisions for you. So that would be, the question of, does a healthcare advanced directive give someone who's your healthcare power of attorney ability to make mental health treatment?
Yeah.
Yeah.
I have to admit, I'm a little bit less familiar with the regular advanced directive Oregon laws. That's something that I know the DMHT statutes forwards and backwards, I think at this point. But if I don't know if there's any prohibitions in the regular advanced directives for using mental health care. I do think you probably could not use a DMHT in the reverse because it's so specific. So much of the language is about consent for mental health treatment. So I do think that prohibition would be there, but I'm not sure about the other way. It's a great question.
Yeah, I think it would be good to ask if whoever you, because the advanced directive overrides a healthcare power of attorney. So if you name someone in your advanced directive, it'll override the healthcare power of attorney person that you have listed. So it would be interesting to find out if, in the same way, if your DMHT person would override, a healthcare power of attorney.
Yeah, I
So
think
if you had two different people, stated, yeah, that'd be good to find out.
I will definitely, I love whenever I do these trainings and I get a little homework, I have to go investigate, learn a little bit more.
Yeah.
If there are other questions, I'm happy to keep answering them. Otherwise, I also have the OHA website up where I can show folks where they can access some of these resources. What do you think? Oh, someone has their hand up.
Hi.
Luhati, do you want to?
Hi.
Yeah, so when I get a new client who is interested in individual therapy, I always create a baseline PHQ-9, GAD-7, and then also the slums. And so if their score is within that dementia range, would it be still appropriate to present to them the DMHT to complete?
That's a great
The
question.
screening tool, the slums?
Yes, yeah. I think that's a great question. And I think the slums isn't going to give us enough specific information about their capacity to consent to mental health care treatment one way or the other, but that is obviously like a concern and an indicator that someone might need a more nuanced assessment. So in that case, I think I don't want to be someone who like generally says anytime that you work with someone with a disability, you need to have a formal assessment of their capacity to consent, because I think that's putting unnecessary barriers on our folks. But in that situation where you have some kind of indicator, you have some kind of flag that says this might be an issue, in that situation, it might be worth it to have those like two physicians, or even just, I mean, in that case, you just need one person to do kind of a capacity assessment. And then hopefully speak to that one way or the other. And if they're in a good spot, go ahead and start that planning process. But if they're not, then maybe that's not a good tool for them. And I'm less of an expert whenever it comes to this area, but my understanding is that for folks who are experiencing dementia, there's sometimes fluctuations in their day-to-day and throughout the day, their capacities. And so it might be something where you have to find a good moment to have those conversations with them and a good moment to initiate with that. But I think that's a wonderful question.
Louisa, you're muted if you are.
Okay, buttons, me and buttons, so many buttons. Okay, thank you. Dawn wanted to share with us that she states, we train everyone to talk with veterans to express their mental health preferences in their advanced directive. This is the first time I'm hearing about the DMHT.
Oh, see, it's so fascinating to me. I learned about these in graduate school, but like I said, I kind of came from a program and a mentor and a research group that was very focused on psychosocial rehabilitation. I feel extremely grateful for the opportunities that I had in that program. But I find that so many people don't know about these. Obviously, I'm a psychologist, so I'm speaking from that perspective. But like one thing that is frustrating to me is, despite my efforts, the Oregon Board of Psychology will not include information about these on their jurisprudence test. They have a jurisprudence test that every psychologist has to take, even if you're coming from a different jurisdiction and you're already licensed. You have to take this test that says, that shows that you understand Oregon laws and how they operate. And it's not on there. And it directly affects the practice of psychology in the state. And so I don't know, these documents sometimes pull odd reactions from people, or I should just say reactions I don't understand. But I think people get nervous around them. People will be kind of dismissive and say like, oh, these won't work, these won't do anything. And then, my response to that is always, they automatically do something by giving someone more control over their own treatment, right? Like even if it wasn't associated with all these cool things like lowered healthcare utilization rates or, lower costs, even if none of that happened, this is still a tool that people can use to have more control in moments when they would otherwise not have that control. And I just don't understand how there's an argument against that.
So one of the things that I think that is good to know that in our advanced directives, we have that section that says that you can add like an addendum, you can add other documents to it. And so typically that's where we add dementia addendums. And so we have, so Dawn, I would imagine a really good thing would be when you're doing your advanced directive with the clients it's like an extra layer of protection. So have them fill out the DMHT and list it and add it to their advanced directive. So that way it's in the medical records, and, you know, it becomes a little bit more of a just more utilized within.
Yeah, I think if you think about that study where consumers said, you know, this helps me be believed whenever I interact with my providers. I mean, how much more powerful is that whenever you walk in with like 4 different documents that are all kind of connected to each other and like clearly well put together, and to say like this is these are my wishes. I saw a hand up and then I lost it. I'm not sure if it's on a different.
Luhati had her hand up, and then we have
Yeah.
another question in the chat.
So we have we're using the 2023 DMHT, and you mentioned that there's an updated version. That page that has the check only one, would that be clarified?
I wish. No, we didn't get that changed in this round. The one where I said it's like the most confusing because you have to either say, you know, I have a representative or my mental health provider is going to follow my instructions. No, that page continues to be confusing. The version that I showed you on the slides is the updated version, and it should be ready by the end of the year on the OHA website. But no, it would be it's in the next round of edits. I will admit I was involved in the legislative work group at the beginning of this year. And I had absolutely no expectation that anything would change. I thought I was going to attend all of these meetings and say a lot of things and be completely ignored and have no changes made. And I was absolutely floored whenever things started happening and felt like I could barely keep up with the requests. But it now gives me hope that maybe we could have a thoughtful, non-reactive opportunity to edit some of these things, like that page that's really confusing. We were just trying to put together the civil commitment like intersection as fast as we could. Definitely building the plane while flying it. But I think that's great. And if people have feedback, if you're looking at these forms and you're like, this makes no sense, or if you read the statutes and you're like, this isn't clear to me, or I don't understand why this would work this way, my email address is in the slides, like 100% email me, and I make no promises that I have any power to make anything change. But if I do, that feedback will be incorporated.
So one more,
Yeah.
since you mentioned that civil commitment, so there's new added verbiage on that civil commitment, like a danger to self, like in the foreseen future. So
Yeah.
if someone completed their DMHT and it's vaguely put together, and then they find somewhere down the road that they need to civilly commit this individual, will the process of that civil commitment supersede what they have on their DMHT if their DMHT is just, you know, kind of vague, like, you know, I don't want this because I'm allergic to it? Further
That's a good question. So that goes back to that intersection between the civil commitment and the DMHT. So once the DMHT is known, they have to go through that court process, right? Where the court says they're capacitated or they're incapacitated. If they're incapacitated, if their DMHT is valid, and then if their DMHT is valid, what does it authorize? And then that goes back to the providers and the investigator and the attorney and the representative and the person, right? And they all decide, are the things that are authorized in the DMHT sufficient to address the concerns that initiated the civil commitment in the first place? So if they are, great, civil commitment process is over. The person is treated according to the DMHT. It is an off-ramp for them from the civil commitment process. If it is not, so in the situation that you're describing where, let's say someone put in their DMHT, I don't want any medications, or I don't want these medications because I'm allergic, but there's no additional detail, or they only named a representative and now that person's not available. Anything like that, then that's a determination. The DMHT isn't sufficient. And so then the civil commitment process continues as it would normally. So it basically provides an opportunity for that off-ramp, which wasn't there before. But you're right, it's not a guarantee. If someone has a DMHT that maybe isn't going to address those concerns sufficiently. Oh, let's see here.
Looking back we've got a clarification from Brooke. She wants to check in on, she states a social worker at a healthcare facility assigned to a client could not be a witness for the client, but can still help fill out the DMHT. Is that correct?
I'm so sorry. Say that one more time.
A social worker at a healthcare facility assigned to a client could not be a witness for the client, question mark. But can we then help the client fill out the DMHT?
Yes, to being able to help the client fill out the DMHT. And if my understanding is correct, if that person who's assigned to that client is their provider, then they cannot be a witness.
Okay.
The list of people who can or cannot be a witness, and the people who can or cannot be a representative is both in the statute and in the form. And so so it's not like something you don't have to like refer back to my slides about it. Whenever you go to fill out the form, there's like a bullet point. In fact, let me, I have the OHA website up. So I'll just share this with the caveat that it is outdated and it's going to be updated soon. So in the slides on the resources page, there is the OHA form. And this is whenever you look on the OHA website about advanced directives, this is the page that you'll see. And so you'll see here are the advanced directive and the PULST. And then you scroll down a little bit and then here is the DMHT. And this is the form. So this is the outdated form. Oh, but there, see, authored in 1994. This is the author of that 1996 study. One of the authors. So here's like the FAQs that I told you about. And I'm just going to move through this very quickly because of time, but also because you already know all of this information. And the instructions for it, it goes kind of step by step, but then you get to the actual statutory form, which is here towards the end. So it's like a 28-page PDF and the last half of it is basically the actual form. So this is like that first slide, but you'll notice that it says, you know, like a period of up to 17 days. So that's not updated. Here's that super confusing part that I told you about that will remain exactly the same, at least for the time being. Here's where you put the name, address, and telephone number of your representative, all of those things. And then, oh, it's up in the directions. That's what it is. In the step-by-step directions, when you choose your representative, choice of decision maker, it says these are the people who cannot be your representative. So it's there in the form. You don't have to memorize that or worry about it. And then affirmation of witnesses. So here are some people who cannot be witnesses. So that is there.
Great. We also have a comment from Sue. Sue states that, oops, hang on. I recently attended a meeting on HB 2005 with OHA and was informed the two capacity evaluators are not evaluating capacity, but rather they are evaluating if someone is incapable or capable.
I think in order to determine if someone is capable or incapable, you have to evaluate their capacity. Because I think that's there may be a confusion then around language. But I think if you're saying you're evaluating if someone has capacity, and if they do have capacity, then they're capable to make their own healthcare choices. And if they don't have capacity, then they're not capable of making their own healthcare choices. So I think those are the same things, maybe just stated slightly differently. I hope that answers your question. But HB 2005 is this one. It was a giant bill. It was like 140 some odd pages, but this part was only one small part of it.
Awesome. Are there any other questions for Dr. Avila? Let's see.
I'll show one last thing
Yeah.
in our last couple of minutes if there are no other questions. Let's see here. So on the resources page, I also somewhat optimistically included the website that I'm creating. So you guys are getting to see the like behind the scenes version, but this is what's there. It's not quite ready yet. And now I have to update it from all the 2025 stuff. But this is intended to be a website that is just very pragmatic. It's going to have information on how people can get started, just like clear links to the form. There's also going to be information for loved ones, for providers, for attorneys, things like that. And then, available research and FAQs. And so anyway, this is the direction that it's heading. So hopefully soon this will be a resource that really helps people with that like pragmatic aspect of being able to have specific answers to their questions about what's happening in Oregon. And then among the other resources, I think there's a podcast that my co-author and I did that could be of interest. And then
I can send that along to people as well.
Perfect. Thank you.
Yeah. Yeah. So we will send anything that you want. So send me an email of all the different things. I really like your logo. That is very lovely with the line through it. Okay. Janine, do you want to close us out for the
Go ahead,
training?
Angela.
Okay. So again, thank you very much, Dr. Avila. And we will send out follow-up emails. One is from us with the slides, a link to the recording, any of the training materials or links to podcasts and different things, and also a survey for the CEU. Folks who attended the entire training are eligible for the CEU. If you do not receive a survey, it's because you might have not attended the whole training. And then also you will receive an email from Portland State University. Here's the email address that it will be coming from with a survey about today's training. You can get a certificate of attendance through that. And you can let us know how we're doing and any future trainings you want us to see craft for you all. So yeah, so thank you all. And I think that's it. Anything else? We will see you next time. Okay.
Thank you, everyone.